$241,600. That's the number a forensic accountant put in front of me on a Tuesday afternoon in March, sliding a manila folder across a conference room table like it was a ticking bomb. I remember the fluorescent light in that office, the smell of stale coffee, the sound of her pen tapping the table twice before she finally spoke. "I want to walk you through this slowly," she said, "because I don't think you're going to like what the numbers show." That's how much my father diverted out of a trust that had my name on it, my name, not my brother's, over the course of 25 years. For 25 years, my father told me I wasn't as smart as my brother Evan, not as driven, not as built for success. That was his phrase, built for success, like some of us come off the factory floor with a defect. Every Thanksgiving, every graduation, every Christmas morning, there it was. Evan got into a better school. Evan got the corner office. Evan got the down payment for his first house as a gift because that's what family does. I got told to work harder. What I didn't know, what I couldn't have known because he made sure of it, was that the money that should have built my future was quietly, deliberately redirected into his. They thought they got away with it. They were wrong. This is the story of how I stopped competing for my father's approval, started asking questions instead, and uncovered a $250,000 fraud that had been sitting in plain sight since I was 11 years old. This is the story of forensic accountants, probate court, a private investigator named Denise who chain-smoked through every phone call, and the exact moment my father realized his own daughter had built a paper trail good enough to take to a district attorney. Stick with me to the end, because the twist isn't just what he took, it's what he spent it on. Welcome back. If you're new here, this channel is dedicated to one thing, telling the true stories of ordinary people who got robbed by strangers, by business partners, and yes, sometimes by their own families, and fought their way back to every single dollar they were owed. Today's story is about greed. It's about favoritism used as a smokescreen, and it's about a woman who had to become her own detective to get justice from the one person who was supposed to protect her.
If stories like this matter to you, if you believe financial predators, even the ones who share your last name, deserve to be exposed, hit subscribe now, because you're going to want to see how this one ends. Let's get into it. My name is Maya. I'm 36 years old, and for most of my life, I thought my problem was that I simply wasn't as good as my younger brother. I need you to understand the shape of my childhood, because none of what comes later makes sense without it. My father, Richard, built a mid-sized commercial real estate firm from nothing. He started leasing strip malls in the early 80s, and by the time I was born, he had a real business, property management, a handful of retail developments, a name people in our county recognized. He was, by every outward measure, a good provider. He paid for a nice house, he paid for private school, he paid for family vacations that looked great in photographs. What he also did from the time I was old enough to understand English was measure me against my younger brother, Evan, who is 3 years younger than me, in front of anyone who would listen. "Evan reads at a 4th grade level and he's only in 2nd grade, he told my grandmother at a birthday party when I was 11. I was standing right there. "Maya's going to have to work twice as hard as her brother," he told my teacher at a parent conference. "She's just not a natural like he is." I want to be clear about something because I know some of you are already thinking it. This wasn't garden variety sibling rivalry. This was a pattern, consistent and deliberate, that lasted 25 years, and it had a financial architecture underneath it that none of us, not me, not my mother, not even my brother, understood until very recently. Here's where the money part starts. When I was 11, my paternal grandfather passed away and left a modest but real inheritance, real estate holdings and a stock portfolio, to be split in trust for the benefit of, his words, both of his grandchildren, me and Evan. My father was named trustee, not a bank, not a neutral third party, my father. At the time, that seemed completely normal. He was our dad. Who else would manage it?
Here's your first red flag, and if you've watched this channel before, you already know to look for it. The person controlling the money and the person benefiting from favoring one party over another were the same person. No oversight, no co-trustee, no requirement to report account activity to the beneficiaries, to me, until I turned 25, per the terms of the trust document, which none of us had actually read closely. Why would we? We were kids. It was Grandpa's money being handled by Dad. Case closed, we thought. For years, the trust was simply background noise. Occasionally, my father would mention, almost boastfully, that he was growing it, reinvesting dividends, rolling maturing CDs into new instruments, playing the market smart, he'd say, tapping his temple. He talked about it the way other dads talk about a fantasy football team. Numbers moving, decisions made, nobody checking his work. I want to give you a few specific memories because I think they matter more than any summary I could give you of favoritism. When I was 12, I made the honor roll for the first time, a real accomplishment for me because I'd struggled with math the year before and worked hard to bring my grade up. My father's response at dinner, in front of my mother and Evan, was, "Good. Now let's see if you can do it again, because Evan's going to be right behind you and he won't need 3 tries." Evan was 9. He wasn't on any honor roll yet. The comparison wasn't even to something Evan had done, it was to something my father assumed Evan would eventually do better, automatically, by nature. When I was 14, I asked to take piano lessons. My father said the household budget was tight that year and suggested I wait until things settle down. 6 months later, Evan, then 11, was enrolled in private tennis coaching that cost, based on records I'd later find, close to $3,000 a year. I didn't know about the cost at the time. I only knew that tight apparently didn't apply equally. My mother, I want to say clearly, was not a co-conspirator in any of this. She worked part-time as a receptionist for most of my childhood and had no independent access to the trust records. My father managed all of the family's finances, including the household budget, and she has told me since all of this came out that she genuinely believed the differences in spending were tied to Richard's business having a good year or a bad year, not to a trust she barely thought about because it wasn't due to be reported to anyone until we turned 25. She now describes handing over financial control to my father early in their marriage as the biggest mistake of her adult life. I believe her. I've seen the bank records. She was kept as much in the dark as I was. There's one more memory from that era I want to include, because it's the one that, looking back, should have told me something wasn't just emotional but structural. When I was 17, I got my first part-time job at a bookstore, mostly because I wanted spending money my parents didn't control. I remember my father's reaction wasn't pride, it was something closer to relief, though I didn't recognize it as relief at the time. "Good," he said. "That's smart. You should always be able to take care of yourself." I took that as a compliment for years. I understand it differently now. He wasn't praising my independence. He was quietly grateful that I was solving a financial problem he had already decided he wasn't going to solve for me, using money that, unbeknownst to me, was sitting in an account with my name on it the entire time. Meanwhile, the favoritism at home kept escalating in ways that, in hindsight, tracked suspiciously well with financial decisions I wouldn't learn about for another 2 decades. When Evan was 16, he got a car, not a hand-me-down, a brand-new Honda Civic, financed, my father said at the time, out of some of his inheritance money since he'll need it for college visits. I was 19 at the time, in my second year of community college because we'd been told the trust doesn't fully vest yet for my education expenses. I took the bus. When Evan started his freshman year at a state university my father was thrilled about, tuition, room, and board were paid in full, no loans, no work study. When I transferred to a 4-year school 2 years later, I was told the trust needed to preserve principal, and I took out $34,000 in federal student loans that I am, as of this recording, still paying off. I remember the exact conversation about my tuition because I've replayed it in my head more times than I can count since finding that folder. I was sitting across from my father at his desk, the same desk, it turns out, where he kept the folder that would eventually expose him, and I asked, directly, whether the trust could cover my remaining 2 years at the university I wanted to attend. He opened a drawer, pulled out what looked like an account summary, glanced at it for maybe 3 seconds, and said, "It's just not there right now, Maya. The market's been rough. We have to be smart." He closed the drawer before I could see the page. I didn't ask to see it. Why would I? He was my father, and he was a real estate professional who talked about markets and portfolios at the dinner table like other dads talked about sports scores. I trusted the 3-second glance at a page I never saw. There was a wedding gift, too, that I only understood the significance of much later. When Evan got married, my father paid for the rehearsal dinner outright, close to $8,000 at a private venue, and told relatives who asked that it was our gift to the happy couple on top of everything else. When I got married 2 years earlier, my father contributed $500 toward the flowers and told me with what I took at the time as genuine regret that things were tighter that year with the business. I didn't think to ask why a multi-decade family trust sitting untouched for my benefit couldn't cover a wedding gift comparable to my brother's, because I still didn't know at that point that the trust even existed in any meaningful sense for me at all. Every single time, there was a story, a reason, a version of financial prudence applied unevenly, always in Evan's favor, always explained to me as being for my own good, or a timing issue, or your grandfather would have wanted us to be careful. I believed it. That's the part that's hardest to say out loud. I believed my father was simply a cautious, responsible steward of money that belonged to both of us, being fair in ways I didn't always understand. Because fathers don't lie to their daughters about inheritance from a man who loved us both. There's a version of this story where I tell you I suspected something for years and simply didn't act. That's not true, and I want to be honest about that instead of making myself sound more clever than I was. I genuinely did not suspect fraud. I suspected favoritism. Plain, old-fashioned, emotionally painful favoritism. The kind therapists talk about. The kind that shapes a person's entire sense of their own worth. I spent years in and out of therapy, trying to understand why I wasn't enough for my father, never once considering that the imbalance I felt wasn't a reflection of anything true about me at all. It was the emotional cover story for a financial crime. The moment that should have cracked it open, the moment money visibly, undeniably changed hands in a way that didn't square with preserving principle, came when I was 28. Evan, then 25, wanted to buy his first house. At his engagement party, held in the backyard of my parents' house under a rented tent with string lights and a caterer my father had insisted on, he stood up with a glass of wine, tapped it with a fork until the yard went quiet, and announced that he was gifting Evan and his fiancée $60,000 toward their down payment, an early distribution, he called it, from what's coming to him anyway. People clapped. Someone's aunt said, "What a wonderful father." I clapped too, because what else do you do at your brother's engagement party in front of 40 relatives? I remember sitting at that table doing math I didn't want to do. $60,000. In cash. Announced like a toast, like a party favor, like something that cost him nothing to say out loud in front of an audience. I remember looking over at my mother, who was smiling the polite, practiced smile she used at events like this, and wondering if she'd known the number in advance or was hearing it for the first time along with everyone else. I never asked her that directly until years later. She told me, once the case was underway, that she had known a gift was coming but not the amount, and that hearing it announced publicly like that had made her uncomfortable too, though she hadn't said anything at the time. Neither of us said anything at the time. That's its own kind of pattern, if you think about it. I asked my father privately, a week later, sitting in his home office with the door closed, when I might expect something comparable, given that the trust was supposed to benefit both of us equally under the terms our grandfather had actually written. He leaned back in his chair, the same desk, and told me the trust for my portion had underperformed, bad market years, poor allocation choices early on that he'd since corrected, for Evan's share, apparently, though he didn't put it that way at the time. He told me, and I remember this sentence precisely because I wrote it down that night in a journal I still have, and have since shown to both Priya and Marcus as corroborating evidence of his own
account of the trust performance. You've always been more independent, Maya. You don't need it the way your brother does. I asked, reasonably, I thought, if I could see the account statements to understand what underperformed actually meant in dollar terms. He told me the statements were with his accountant and he'd pull them together sometime. He never did. I didn't ask again for 8 years. I didn't push further. I want to be honest about that, because I think a lot of people watching this have been in a version of this position, where pushing back against a parent, even when the math doesn't add up, feels like a betrayal you're not willing to commit. So I let it go. I told myself a story about being the independent daughter, the strong one, the one who didn't need help. I turned that insult into an identity, because the identity hurt less than the alternative explanation. The alternative explanation, it turns out, was fraud, and I wouldn't find the proof of it for 8 more years. Not until a medical emergency put me, by accident, in a room I was never supposed to be in front of a folder I was never supposed to see. The thing that finally broke the story open wasn't suspicion. It was an accident, the kind of small administrative accident that changes a life. 3 years ago, my father had a minor stroke. Not catastrophic, but serious enough that for about 6 weeks, he was in a rehabilitation facility, and my mother, overwhelmed, exhausted, trying to manage his medical care, asked me to help organize his home office so she could find his insurance paperwork. I remember that afternoon specifically. It was a Sunday. The office smelled like the cedar closet freshener my father had used for as long as I could remember. And there were stacks of paper everywhere, the kind of accumulated clutter you only get from someone who doesn't trust digital records and keeps physical copies of everything just in case. I was looking for a specific insurance policy number my mother needed for a hospital billing call. Instead, in the third drawer of an old metal filing cabinet, behind a hanging folder labeled Taxes, Old, I found a second, unlabeled hanging folder, and inside it, a manila folder with a tab that read, in my father's distinctive block handwriting, M/E Trust Master. That's where I found it. Inside were copied statements going back decades, some of them yellowed and brittle at the folds, some more recent and printed from an online brokerage portal in the flat gray toner of a home printer running low on ink. I want to walk you through what I actually found, because the details matter.
The original trust, established when my grandfather died, held approximately $310,000 in combined assets, a rental duplex that was later sold, and a diversified stock and bond portfolio. Per the trust document, which I finally actually read in full that week, sitting on the floor of my father's office at 1 a.m., the assets were to be divided and managed in equal shares for the equal benefit of my brother and me, with distributions permitted for health, education, maintenance, and support, a standard legal phrase you'll hear referred to as the HEMS standard if you ever deal with trust law yourself. What the statements showed was not equal management. It was a slow, patient, decades-long transfer. I found a 2004 statement showing a $22,000 withdrawal, labeled in my father's own notes as E, summer camp/tutoring, when Evan was 11. I checked my own memory and my mother's old calendar, which she still had boxed up. Evan did not attend a $22,000 summer camp. He went to the same 2-week day camp I did, which cost at most a few $100s.
I found a 2011 statement showing $18,500 withdrawn and labeled E, college prep/SAT. The same year, Evan took a standard SAT prep class that, based on the receipt I later found in my mother's records, cost $650. I found a 2015 statement showing a $9,800 withdrawal labeled E, car repair. The same year, according to a receipt I later found my mother had kept for an entirely unrelated reason, that Evan's actual car repair, a transmission issue on the Civic he'd been given at 16, cost $1,140. And then I found the pattern accelerate. A $60,000 withdrawal in the same month as that engagement party, labeled simply E, house. Sitting there on the floor, I did something I don't think I'd ever done before in my adult life. I made a physical list on the back of an old envelope, adding the numbers by hand because I didn't trust myself to do the math correctly in my head, because some part of me wanted to be wrong. I wasn't wrong. Total withdrawals labeled for Evan's benefit across the folder, just over $187,000. Total withdrawals labeled for my benefit across the same 25 years, $6,200. One entry, when I was 19, the year I took the bus to community college, read M, MISC/tuition partial for $6,200 against $34,000 in loans I ended up taking out myself. And that's when I found the smoking gun.
Tucked behind the statements was a single sheet of yellow legal paper in my father's handwriting, dated 11 years earlier, that read like a private confession he never meant anyone to see. It said, verbatim, "Keep M's share conservative, she'll never check. E needs more runway, even out on paper if she asks." He had written it down. He had planned it, and he had specifically anticipated that I might one day ask questions and had a plan to even out on paper, to falsify records if that day came. I sat on that floor for close to 2 hours. I didn't cry, not right away. What I felt first was something colder, a kind of recalibration, like watching a photograph you've looked at your whole life suddenly resolve into a different image entirely. Every "you're the independent one," every "you don't need it the way your brother does," every bus ride while Evan drove his new Civic. It wasn't a personality difference between my brother and me, it was a cover story for theft. I want to talk for a moment about what this actually cost me, beyond the dollar figure, because I think the financial number, as large as it is, understates the real damage. There's the practical layer, the $34,000 in student loans I took out and am still paying interest on, money I would not have needed to borrow if my actual share of the trust had simply been used the way it was legally supposed to be used. There's the compounding layer, the retirement contributions I couldn't make in my 20s because I was paying down debt instead, money that, invested even modestly over 15 years, would be worth significantly more today than the loan balance itself. And then there's the layer that doesn't show up on any balance sheet at all. 15 years of believing, on some level, that I was less capable, less built for success than my brother, an entire adult identity constructed around a lie my own father manufactured and then funded with money that was supposed to be mine. I've spent real money on therapy trying to unlearn that belief. I don't think I'll ever get a clean accounting of that particular cost the way Priya could give me a clean accounting of the trust. My initial instinct, and I think this is a very human instinct, was to try to resolve it quietly, inside the family. I didn't want to believe I needed lawyers. I wanted to believe there was an explanation. So a few weeks after my father was released from rehab, once he was stable and clearly of sound mind, I want to be precise about that because it matters legally, and I'll explain why in a minute, I sat down with him and my mother and laid the folder on the table. I remember exactly how he reacted to seeing it. Not surprise, not the confusion of someone shown a document they don't recognize. He picked it up, flipped through 4 or 5 pages without really reading them, the way you skim something you've already memorized, and set it back down. "Where did you get this?" he said.
It wasn't really a question.
I told him. My mother, who hadn't seen the contents until that moment, went very quiet as I walked through what the numbers showed, and I watched her face change in a way that told me, more than anything my father said that night, that she genuinely hadn't known. He didn't deny it, not exactly. What he did was worse. He minimized it. He told me that everything evens out eventually, that he'd always intended to make it right in his will, that I was making a family issue into a legal issue by bringing documents into the conversation instead of just talking like a family. I asked him directly, did he use trust assets that were legally designated for my benefit to pay for things that benefited only Evan? He said, and again I wrote this down that same night, I made judgment calls as trustee. That's my right. That sentence is where this stopped being a family disagreement and started being a legal one, because trustees do not, in fact, have an unlimited right to make judgment calls that favor one beneficiary over another when a trust document specifies equal shares. That's not a family issue. That's what's called a breach of fiduciary duty, and depending on how a court chose to characterize it, potentially elder or dependent adult exploitation statutes wouldn't apply here since he was the trustee, not the victim, but self-dealing and breach of trust absolutely would. My first attempt to resolve this without lawyers failed within about 15 minutes of that conversation. My father stood up, said I was poisoning the family over money, and left the room. My mother, to her credit, looked genuinely shaken. She told me later she had no idea the trust had ever been managed unevenly. She'd trusted him with it completely, the same way I had. Over the following month, I tried twice more. I asked for a full accounting, a legal term meaning a detailed record of all trust transactions, which any trustee is generally required to provide to a beneficiary on request. He refused, verbally, both times, saying the records were old and not organized, and that I should let it go before I ruined this family. The second attempt was the one that changed everything for me, because it's the one where I finally understood that family was the word he was using as a weapon, not a value he actually held. I called him and asked calmly for a written accounting. Nothing hostile, just a request that he put in writing what he'd already told me verbally, so I'd have something concrete to review. He was quiet for a long moment, and then he said something I've replayed more times than almost anything else in this entire story. You've always wanted to be the one who suffers, Maya. Don't turn this into that too. I sat with that sentence for days. He wasn't denying what the numbers showed. He was trying to reframe my request for basic financial transparency, something any trustee is legally obliged to provide, as a personality flaw, a chosen identity, something I was doing to myself rather than something that had been done to me. It was the same move he'd made my entire childhood, just aimed at a different target. And for the first time in 28 years, I recognized it while it was happening instead of years later. The third attempt, a week after that, was the shortest. I emailed him a simple written request for a full accounting of the ME Trust with a specific deadline and copied my mother. He never responded to the email at all. Silence, it turns out, is also an answer. That refusal is what pushed me from hurt daughter to someone building a case. Because here's the thing about people who cover their tracks over 25 years. They get comfortable. My father assumed, correctly for a long time, that I would never look closely enough to catch him. What he didn't anticipate was that the folder he kept, the one with his own handwriting laying out the scheme, would end up being the single most damaging piece of evidence in the entire case. I want to walk you through exactly how I built this case, step by step, because I think the process matters as much as the outcome. If you're watching this because something similar is happening in your family, this is the part you need to pay attention to. Step 1. I stopped talking and started documenting.
The day after my father refused to provide an accounting, I photographed every single page in that folder with my phone, then made physical photocopies at a UPS store and stored the originals somewhere he had no access to. I want to underline this for anyone in a similar situation. If you find evidence like this, do not confront the person again until you have secured copies. My father, I later learned, went looking for that folder about a week after our conversation. It was gone from his office by then, into a safe deposit box under my name alone. Step 2. I found a forensic accountant. I'd heard the term, but didn't fully understand what it meant until I sat across from one. A forensic accountant is a financial investigator, someone trained to reconstruct financial history from incomplete records, trace fund flows, and testify in court about what they find. I found mine, a woman named Priya, through a referral from an estate attorney a friend had used for an unrelated matter. Her retainer was $4,500, which felt like an enormous amount of money to spend chasing money I wasn't sure I'd ever recover. It was, in hindsight, the best financial decision I've ever made. Priya spent 6 weeks going through everything, the statements from the folder, plus records she subpoenaed later once we had legal standing, from the brokerage firm directly, plus tax records, plus property records for the duplex that had originally been part of the trust. Her process was more methodical than anything I expected. She started by building what she called a transaction timeline, every withdrawal, deposit, and transfer she could document in chronological order, cross-referenced against my father's own labels where they existed, and flagged as unlabeled or unexplained where they didn't. She then cross-checked the labeled expenses, the summer camp, the SAT prep, the college prep line items, against any independent records she could find. Old receipts my mother had kept, school billing records I was able to request directly from my former high school and community college under public records provisions, and in one case, a credit card statement from my mother's own separate account that happened to show the real, much smaller charge for the same expense my father had inflated on paper. She also ran what's called a net worth analysis on my father personally, a standard forensic accounting technique that compares a person's known documented income against the growth of their personal assets over the same period. If someone's assets are growing faster than their documented income can explain, that gap is often where diverted funds surface. My father's personal net worth, according to Priya's analysis, grew by an amount during the relevant period that his real estate income alone could not account for, a gap of roughly $61,000, which, as you'll hear shortly, turned out to be enormously significant. Getting the underlying bank and brokerage records wasn't simple either. Financial institutions won't hand over a third party's account history just because someone asks, even a beneficiary with a legitimate claim. They require a valid subpoena or court order first, and the brokerage firm my father used took nearly 6 weeks to fully comply with ours, citing internal compliance review before releasing anything. Once the records came in, they arrived as an enormous, disorganized stack of PDFs spanning more than 2 decades, and Priya's team spent days simply standardizing the formatting so the numbers could be searched and cross-referenced at all. I remember asking her, somewhat naively, why this had to take so long, and she told me something that stuck with me. People think forensic accounting is dramatic. Mostly it's just extremely patient reading. And that's when I found the smoking gun, the second one, because it turns out there was more than one. Priya discovered that in addition to the labeled withdrawals I'd found in the folder, there was a pattern of unlabeled transfers, money moved from the trust's brokerage account into an LLC my father had quietly formed 9 years earlier called Cedar Line Holdings. Cedar Line Holdings, it turned out, was the entity that technically owned 2 rental properties my father managed personally and collected income from, income that never once appeared in any accounting to me or my brother, and that Evan, to my genuine surprise, also knew nothing about. Total transfers into Cedar Line from the trust was $54,600, moved in 11 separate transactions over 4 years.
always just under amounts that would have triggered additional bank reporting scrutiny. A pattern that, when Priya pointed it out, made the hair stand up on my arms, because it suggested this wasn't sloppy favoritism anymore. It was deliberate structuring. Step 3, I tracked down a witness. Before I ever hired an attorney, I wanted to understand how Cedarline Holdings actually functioned day to day, because a name on a document only tells you so much. I remembered that my father had used a part-time bookkeeper for years, a woman named Sandra, who used to come by the house occasionally when I was a teenager to help with the business paperwork. I found her through an old holiday card address my mother had kept, and I called her, explaining honestly that I was trying to understand some financial history involving my father. Sandra was cautious at first. Understandably, she'd been paid by my father for over a decade and had no obligation to talk to me at all. But when I described what I'd found, she went quiet, and then she told me something I hadn't expected. She had stopped doing bookkeeping for Cedarline Holdings 3 years earlier, specifically because she'd noticed transfers coming in from an account she didn't recognize, labeled only with initials. And when she'd asked my father about it, he told her it wasn't relevant to what she needed to track, and to just record the deposits without categorizing the source. She said it had bothered her enough that she quietly kept a personal note of the dates, just in case it ever mattered. It mattered. Sandra's notes, once we compared them against Priya's later reconstruction, matched almost exactly. I also did something that felt almost embarrassingly simple. I searched Cedarline Holdings' name alongside my father's and found that the LLC had a bare-bones public business page, along with a local newspaper photo from a small business networking event 4 years earlier, showing my father standing in front of a banner for the company, smiling, described in the caption as the founder and principal of Cedarline Holdings, a company he had told a probate court months later he didn't actively manage. Step 4, I brought in an attorney who specialized in trust and estate litigation. His name was Marcus Feld, and the first thing he told me in our consultation was something I want to pass along to anyone watching who's in a similar spot. The law is actually very clear here. A trustee has a fiduciary duty of loyalty and impartiality to all beneficiaries. What your father did, assuming the documents hold up, isn't a gray area. It's textbook self-dealing and breach of trust. Marcus explained the statute of limitations question, which had been keeping me up at night. In our state, the clock on a breach of fiduciary duty claim generally starts running not from when the breach occurred, but from when the beneficiary discovered, or reasonably should have discovered, the breach, a legal concept called the discovery rule. Since I'd only found the night folder 8 weeks earlier, we were well within the window, even though some of the original withdrawals dated back over 20 years. We filed a petition for accounting in probate court, a formal legal demand that forces a trustee to produce complete financial records under penalty of contempt. My father had 30 days to respond. Early on, I asked Marcus whether this was something the FBI or the FTC could get involved in. I'd watched enough of these stories myself to assume federal law enforcement was always part of the answer. He explained that federal agencies like the FBI generally get involved in fraud cases that involve wire fraud across state lines, organized schemes targeting multiple victims, or financial institution fraud, not typically a single family's internal trust dispute, however large the dollar amount. The FTC, similarly, focuses on consumer protection and deceptive business practices affecting the public, not private trust administration between family members. What we had, as frustrating as it was to hear, was fundamentally a civil matter, a breach of fiduciary duty between a trustee and a beneficiary to be resolved in probate court, not a federal case. That reality shaped our entire strategy, building an overwhelming civil record instead of waiting on a criminal referral that was unlikely to come. This is where things got tense in a way I wasn't prepared for. Near miss number 1,
2 weeks after we filed, my mother called me in tears to say my father was talking about liquidating Cedar Line Holdings and simplifying things, which Marcus immediately recognized as a potential attempt to move or hide assets before a court could freeze them. We went back to the judge and requested what's called a temporary restraining order on trust and related LLC assets, arguing there was a demonstrated risk of dissipation. The judge granted it within 4 days. If we'd waited even another week, Priya believes a significant portion of the Cedar Line assets could have been transferred out of reach entirely. Near miss number 2. My father, through his own attorney, tried to argue that the original trust document was ambiguous about equal shares and that his discretion as trustee under the HEMS standard gave him broad authority to distribute unevenly based on each beneficiary's individual life circumstances. For about 10 minutes, listening to him talk, I understood exactly how my father had gotten away with this for so long. He'd always been good at making theft sound like care.
What sank that defense was the yellow legal pad. Marcus stood up, entered it into evidence, and read it aloud, slowly into the record. Keep M's share conservative. She'll never check. E needs more runway. Even out on paper if she asks. He let the silence sit for a moment before he spoke again. Your Honor, this is not the language of a trustee exercising good faith discretion under the HEMS standard. This is the language of a man planning and writing to falsify records in the event his daughter ever asked to see them. That is not language a person writes if they genuinely believe they have legitimate discretionary authority. It's language a person writes when they know they're doing something they don't need to hide. The judge asked my father's attorney directly whether he had an alternative explanation for the note's contents. He did not. Marcus called it afterward, in his words, a self-authored confession, and once it was entered into the record, my father's attorney stopped raising the ambiguity argument entirely. Near miss number 3. About 3 months in, Sandra, our bookkeeper witness, called Marcus's office to say my father had reached out to her directly, reminding her she'd signed a standard confidentiality agreement years earlier when she did his bookkeeping, and hoped she'd remember her obligations. Marcus was blunt with me about what this was, an attempt stopping just short of anything he could be directly charged for to intimidate a witness into silence. We filed an emergency motion asking the court to formally instruct my father through counsel not to contact any identified witnesses directly. The judge granted it the same week. Sandra later testified anyway, but Marcus told me plainly that if she'd gotten spooked and backed out before that order was in place, we would have lost one of our strongest pieces of independent corroboration. Near miss number 4, and the closest call of the entire case. Roughly 5 months in, my father offered a private settlement directly to me, bypassing the attorneys, at a family dinner my mother had organized in what I now understand was a genuine attempt to keep the family together. He offered $75,000 to make this go away, on the condition I sign a non-disclosure agreement and drop the court case entirely. I remember the dinner itself in a lot of detail because I've gone over it so many times since. It was at a quiet Italian restaurant my parents had gone to for their anniversary for years, the kind of place with cloth napkins and a waiter who knew my father's name. He waited until we'd ordered, until my mother had excused herself to the restroom in what I now suspect was a planned break so he could speak to me alone, and then he reached into his jacket pocket and slid a folded piece of paper across the table, a handwritten number, not even a formal offer, just $75,000 in his handwriting, and the words, "Let's fix this as a family." "This doesn't have to go any further," he said. "You get real money today, no waiting on a court. We put this behind us." $75,000 against a documented total, once Priya finished her final reconstruction, of $241,600 in diverted trust assets. He was betting that I'd take a fraction of what I was owed just to end the conflict. For about a day, I genuinely considered it. Not because I thought it was fair, but because I was exhausted, and because some part of me still wanted my father to be a person who'd simply make things right, rather than a person I had to legally defeat.
There's a specific kind of tiredness that comes from litigating against your own parent that I don't think anyone fully understands unless they've lived it. Every filing, every deposition prep session, every conversation with Marcus is also, underneath the legal language, a fresh confirmation that your father is a person willing to let you take a bus to community college while funding his other child's private tennis lessons with money that was never his to redirect. I called Marcus that night. He said something I still think about. He's not offering you $75,000 because he thinks that's fair. He's offering it because his lawyer told him what happens if this goes to a full accounting and a judge sees everything Priya found. This is a man trying to buy silence before the real numbers come out. He also pointed out something I hadn't considered. The non-disclosure agreement my father wanted me to sign would have prevented me from ever discussing the trust, the accounting, or the underlying facts with anyone, including, notably, my own brother, who at that point still had no idea any of this had happened. That detail settled it for me more than anything else. My father wasn't just trying to buy my silence, he was trying to buy Evan's ignorance too, permanently, using my signature to do it. I declined the settlement. We proceeded to a full court-ordered accounting. The court-ordered accounting took another 4 months. My father's attorney fought nearly every subpoena Priya and Marcus filed, which, as Marcus pointed out, is itself often read by judges as evidence of concealment rather than legitimate defense. When the full picture finally came together, here's what it showed. Total trust assets diverted for the exclusive benefit of my brother, disguised as legitimate trust expenditures, $187,000, spanning purchases including the summer camp/tutoring line that was actually a few $100s of real expense, inflated by over $21,000. The SAT prep inflated by roughly $17,800, and the $60,000 house down payment. Total assets transferred into Cedar Line Holdings, an LLC controlled solely by my father, generating rental income he never disclosed to either beneficiary, $54,600, plus an additional $6,400 in accrued, undistributed rental income the accounting revealed Cedar Line had generated and simply retained. Grand total of trust assets improperly diverted from my equal share, $241,600 before interest.
Under our state's trust law, a beneficiary who successfully proves breach of fiduciary duty is generally entitled not just to the return of the diverted principal, but to what's called surcharge, essentially restitution plus the investment growth those assets would reasonably have earned had they remained properly invested in the trust, calculated by Priya at an additional $68,400 based on the trust's own historical rate of return. The court can also, in cases involving deliberate concealment, award attorney's fees against the trustee personally rather than out of trust assets, which the judge in our case did, citing the yellow legal pad specifically in her written ruling as evidence of willful and premeditated breach. The final judgment, $241,600 in principal, $68,400 in surcharge, and $58,000 in attorney's fees and costs awarded against my father personally, a total judgment of $368,000. I was in the courtroom when the judge read the ruling aloud. My father sat 2 tables away in the same gray suit he used to wear to my school events, staring straight ahead while she read through the findings, the labeled withdrawals, the Cedar Line transfers, the yellow legal pad, all of it laid out in the flat procedural language of a formal court order. I didn't feel triumphant in the moment the way I expected to. Mostly I felt very still, like I was finally allowed to exhale after holding my breath for the better part of a year. My mother, sitting beside me, reached over and held my hand through the entire reading. She didn't say anything. She didn't need to. My father was removed as trustee by court order, a step Marcus told me is relatively unusual outside of cases with clear documented misconduct, which ours, thanks to that folder, unquestionably was. A neutral corporate trustee, a trust department at a regional bank, was appointed to manage what remained of the original trust and to oversee distribution of the judgment. Because Cedar Line Holdings had been funded substantially with misappropriated trust assets, the court also ordered a constructive trust over the 2 rental properties it owned, a legal remedy that essentially says because you bought this asset with money that wasn't yours, the asset itself or its value belongs to the people you stole from. One property was sold at auction. The proceeds went directly towards satisfying the judgment. My father kept the second property, but now carries a lien against it that will follow him until the judgment is paid. I want to be honest that this never became a criminal case, and I think that surprises people. Marcus explained early on that self-dealing by a trustee, absent additional factors like outright forged signatures or clear evidence intended for a prosecutor's threshold, most often plays out as civil litigation rather than criminal prosecution. The county district attorney's office, which we did consult, declined to pursue charges, citing limited resources for what they classified as a family civil trust dispute rather than a criminal fraud referral. That was frustrating to hear, but the civil judgment, the surcharge, the personal liability for legal fees, and the public court record, anyone can now pull that judgment in a search of county civil records, delivered something close to accountability anyway.
There was also a consequence my father hadn't accounted for, and I'll admit I take a complicated satisfaction in it. My father's real estate firm, the one he built his entire reputation on, does business with a fairly small, tight-knit network of local investors, brokers, and commercial tenants in our county. Civil judgments involving breach of fiduciary duty by a licensed real estate professional are a matter of public record, and it didn't take long for people in that network to start asking questions. He didn't lose his license. The judgment wasn't tied to his professional conduct in a way that triggered a state licensing board review, but Marcus told me later, secondhand, that at least 2 long-standing business relationships my father had relied on for years quietly dissolved within about 8 months of the judgment becoming public. Nobody sent him a letter explaining why. People in small professional communities rarely do. They just stop calling. As for Evan, my brother, who genuinely had no idea any of this was happening, this is in a strange way where the story gets its most human. When the full accounting became public through the court filing, Evan called me. He was horrified, not just at what my father had done to me, but at what it meant about how he'd been treated too, used, without his knowledge, as the excuse for a fraud he never asked for and never benefited from in any way he understood as fraudulent. He told me the down payment money, at the time, was framed to him as, "Your grandfather always favored the idea of buying a first home young," a story, not a confession. Evan has since voluntarily contributed a portion of what he received towards satisfying my judgment, which was never legally required of him, and which meant more to me than almost anything else that came out of this entire process. Here's the twist I promised you at the top of this video, what my father actually did with the money once it left the trust entirely, beyond what went to Evan's house and college prep. Roughly $61,000 of the Cedar Line rental income and additional undisclosed trust transfers, once Priya traced them fully, went toward my father's own investments in a separate personal brokerage account, an account that notably existed under his name alone, with no connection to either of his children. He wasn't just favoring my brother. Over the last several years of the scheme, a meaningful and growing share of what he took wasn't going to Evan at all anymore. It was going to himself. 25 years of being told I wasn't as good as my brother, and a real, documented percentage of the money that funded that story wasn't even benefiting the sibling I was being compared to. It was benefiting the man doing the comparing. As of this recording, I've recovered $214,000 of the $368,000 judgment through the auctioned property, a court-ordered lien on my father's remaining assets, and structured payments the court is enforcing. And that's when I found the last smoking gun of the entire process. Not evidence of new wrongdoing, but confirmation of just how deliberate the original scheme really was. When the court-appointed corporate trustee finally took over management of what remained of the original trust, they discovered my father had, 11 months before I ever found the folder, quietly changed the mailing address on record for annual trust-related tax documents from our family home to a P.O. box he controlled personally. A small, easy-to-miss administrative change that would have ensured that even if I had, back then, requested basic tax paperwork tied to the trust, it would never have reached me. It wasn't proof of a new crime, it was proof that he had been actively managing the risk of discovery right up until the moment I found that folder by accident. The remainder of the judgment continues to accrue interest until it's paid in full, and the court-ordered payment structure gives my father a set number of years to satisfy the balance before additional collection remedies, including wage garnishment against his firm's draws, become available to us. My relationship with my father is, as you'd expect, fundamentally different now. We speak occasionally, briefly, and every conversation happens through attorneys when money is involved. My relationship with my mother, who I believe genuinely didn't know the scale of what was happening, has actually grown closer. She moved into her own apartment about a year into the litigation, has her own accountants now for the first time in her adult life, and told me recently that reviewing her own bank statements every month, something she'd never done in 38 years of marriage, has become almost a form of therapy for her. My relationship with my brother has become, unexpectedly, one of the most honest relationships in my life. We talk now about things neither of us would have said out loud 5 years ago, including, eventually, the fact that Evan spent years believing he was simply the favorite, never once imagining that favoritism was the cover story for someone else's theft, and that being used that way without his knowledge or consent for 25 years was its own kind of harm. Last month, he asked if I wanted to split the cost of a real financial planner, a fee-only fiduciary this time, someone with no family connection to either of us to help us both actually understand our own finances going forward, instead of relying on anyone's word for it. I said yes immediately. It felt, more than almost anything else in this entire process, like the actual ending. If there's one thing I want you to take from this story, it's that financial abuse inside families very often hides behind an emotional narrative, a story about who's smart or independent or doesn't need help, because that story is easier for everyone to accept than the alternative, which is theft. So here are the warning signs, drawn directly from what I lived through, in case any of this sounds familiar to you. 1. A single family member controls shared assets, a trust, an inheritance, a family business, with no independent oversight, no co-trustee, and no regular reporting to the other beneficiaries. 2. Financial decisions consistently over years favor one sibling or family member, always accompanied by an explanation about that person's individual needs or circumstances rather than the terms of the actual governing document. 3. You are discouraged, gently or otherwise, from asking to see the actual paperwork, the trust document itself, the account statements, the accounting. Trust me is not a legal substitute for an accounting you are entitled to request. 4. Large financial gifts or early distributions are announced publicly and framed as generosity, while your own requests for comparable treatment are met with explanations about market performance or timing that you're never shown documentation for. 5. If you ever do gain access to records, look for unlabeled transfers, newly formed LLCs connected to the person controlling the money, and dollar amounts that seem to inflate suspiciously round expenses. 6. Pay attention to your own reframing. If your instinct, every time something doesn't add up, is to explain it away, I'm just the independent one, money makes things awkward, it's not worth the fight, ask yourself honestly whether that explanation originally came from you, or whether it's one you were given, repeatedly, by the person benefiting from you not asking questions. 7.
If you do request records and get resistance, vague answers, delays, it's complicated, or guilt about ruining the family, treat that resistance itself as information. A trustee or financial fiduciary managing things honestly rarely has a reason to withhold basic documentation from the people legally entitled to see it. If you're a beneficiary of any trust, whether you're 11 years old and don't know it yet or 45 and have simply never asked, you have a legal right, once you're an adult, to request a full accounting. Use it. I waited 25 years to ask a question I was legally entitled to ask at 25. Don't wait that long. I think about that yellow legal pad more than almost anything else from this whole process. She'll never check. That was the entire foundation the scheme was built on, not some brilliant, undetectable financial maneuver, just a quiet bet that I would never look. For 25 years, that bet paid off. It stopped paying off the moment I finally did. And that, in the end, is the smoking gun I keep coming back to. Not the dollar figures, not the LLC, not even the confession my father wrote in his own hand. The real evidence was the fact that he needed a plan at all. You don't need a contingency for a lie unless you already know it's a lie. I spent 25 years competing for a version of my father's approval that, it turns out, was never actually available to me on any terms. Not because I wasn't good enough, but because the entire structure was rigged before I was old enough to understand there was a structure at all. I stopped competing the day I found that folder. I didn't stop because I won some contest.
Against my brother. I stopped because I finally understood there had never been a fair contest to begin with, only a story, told convincingly enough for long enough that I built my whole sense of my own worth around losing it. Getting every dollar back mattered, but understanding that the loss was never really about ability, never about being built for success or not, mattered more. If something in this story sounds like your own family, I want to hear about it. Have you ever discovered that financial favoritism you grew up with wasn't really favoritism at all, that there was something underneath it? Tell me what happened in the comments. I read every single one. And if you believe stories like this deserve to be told, if you believe financial predators, even the ones sitting at your own dinner table, deserve to be exposed, subscribe, and I'll see you in the next one. This video is a dramatized account based on real events. Names, identifying details, and certain circumstances have been altered to protect the privacy of those involved. This content is intended for educational and entertainment purposes and does not constitute legal or financial advice. If you suspect you are a victim of financial exploitation by a trustee, executor, or family member, consult a licensed attorney in your jurisdiction regarding your specific rights and options.